Deborah Peel for her tireless work in convening this conference. Some of you might know Deb was one of the pioneers, right? That one of the first to ring the alarm bells about patient privacy rights and the issues happening with health data. So I really want to thank her for her tireless and continuous work in this area. So throughout the day, you've heard eye-opening talks about the technological advances in health data collection, and also, as you just recently saw, the different ways in which your health data is actually quite porous. All the different ways that your health data flows from your doctor's office to advertisers, corporations that you're not even aware of and that you didn't necessarily consent to have your data end up in. But quick show of hands, how many people here work for themselves? How many people here are their own boss? That's actually a high number, right? So that's a very high number, actually. For the rest of us, right, who work for others, we actually depend on our employer for our health insurance, right? We are sort of at the mercy of our employers to get health insurance. That's the way of American life. So I would actually like to refocus our attention on the workplace and the way in which health data in the workplace can actually open up arenas for both privacy violations and also discrimination. So the workplace has always been a place where surveillance takes place, right? Starting with Taylorism, moving to Fordism, team building exercises, and finally wellness programs. Workers have always been surveilled, and employers have always felt a need to surveil workers because they feel that this is a way to ensure that workers will be productive and are not wasting company time, reading Facebook, are not wasting company time, not working, are not stealing company resources, right? But the distinguishing factor between what we have now in terms of worker surveillance versus Taylorism and Fordism is the actual focus. So with Taylorism, the focus was on the job task itself, right? Workers were mostly being surveilled by how they completed the work task, with the goal being that mastery of the job task would result in higher efficiency gains, right? If you studied the job task, you could sort of automate it, right? Such that all the workers could be substitutable, you could get the work done faster. And with Ford, you actually had Ford stalking the factory with a stopwatch to observe how fast workers could work. And he created the so-called sociological department, which was basically a bunch of detectives he sent to spy on his workers in their homes and outside wherever they went. So the sociological department of Ford would actually investigate how workers spent their money, if they were drinkers, or if they had marital issues. And this was a way for Ford to determine who was worthy enough to work in his factories because it was deemed a good place to work. Perhaps similar to some tech companies these days, because Ford paid a somewhat higher wage. The distinguishing factor these days in worker surveillance, however, is that the attention is now no longer just on the work itself. The attention is now on the body of the worker. So the focus has shifted to the corpus of the worker, with the idea that mastery of the worker's body will lead to higher productivity and cost savings, right? Because your employer, in the lack of universal health care, is your insurer. They bear the risk, they bear the cost of insuring you, right? So for them, ensuring that your body is mastered, meaning ensuring that you eat well, you exercise, you do all the correct medical things that are necessary if you have a condition. This means you're a better worker and that you will cost them less money. So what's the solution for this? What is the market response to this? Well, wellness programs, right? Wellness programs represent a $6 billion annual industry. And there are over 500 wellness program vendors, approximately, there probably is more, currently operating in the United States. And wellness program vendors advertise a high rate of return. One study claimed a 6-to-1 ROI. Of course, this has more recently been debunked, but that is still how wellness programs are presented. They're presented as beneficial for businesses and as benevolent to workers, right? Workers should appreciate wellness programs because these are programs that will enable you to live a better life. They are programs that will enable you to live your best physical life and be the best you can be. And the question is, does this really live up to its promise? Well, first of all, let's talk about wellness programs themselves. Wellness programs are not regulated by the American Medical Association, which means that any advice given by wellness programs are not necessarily backed by sound medical research, right? So you have wellness programs which are purporting to show you the way to lose weight and show you the way to cease smoking, yet they're not actually necessarily always bound by sound medical advice, okay? Let's also look at the information collection that goes into wellness programs, right? As someone started to mention, wellness programs actually enjoy the support of the US government. So an overlooked provision of the Affordable Care Act is that wellness programs are exempted, for the most part, from being a HIPAA violation, meaning that your employer, through wellness programs, can ask for your medical information. And not just your medical information, they can actually ask for your family medical history, right? And actually, recent EEOC rulings allow for your employer to also ask for your spouse's medical information. So your spouse didn't sign up for this wellness program, yet your company now holds your information also. And you might be asking, well, how is this possible? Why would anyone give up all this information? Well, the ACA also makes getting this information easier for companies. Why? Because it allows organizations, corporations to give incentives, right, for employees to give up this information. So, for example, the ACA allows that employees can get a 30% reduction of their premium, of their healthcare premium, by giving up information and joining a wellness program. 30%. And that's for when they join programs that try to do obesity reduction, right? Weight loss programs. If they join a wellness program that's aimed at smoking cessation, then they can get an up to 50% premium reduction. Is that sounding attractive? If your premium is, say, $1,000 a year, would you like a 50% reduction? Yes, you would. You would willingly sign up and give up all this information, right? And perhaps you'd think nothing of it. You would think, I'm signing up for a program that's going to help me lose weight. I'm signing up for a program that's going to help me stop smoking. These are good things. And it's a win-win, right? Because then my employer also would save money from healthcare costs. Well, first of all, there's actually no evidence yet that wellness programs work, because there hasn't actually been peer-reviewed research looking at wellness programs over time to show that they actually live up to their promise. Secondly, it's not necessarily win-win for the employee, especially. First of all, there's a privacy issue connected with wellness program vendors. Are they covered by HIPAA? Well, depends. Is the wellness program vendor a healthcare provider? In a lot of cases, they are not. And therefore, HIPAA would actually not apply. So for example, recently the Wall Street Journal ran a story in which it revealed that Walmart had hired Castlight, which was a wellness program vendor, and one of the things it tasked Castlight with doing was figuring out how many of its employees were pregnant or were soon to be pregnant. Why would Walmart care to know this information, right? You wonder, right? So even if this information is quote unquote de-identified, right, it could still cause Walmart to take actions that are actually discriminatory. So for example, if Castlight reported that a high number of female employees were pregnant, maybe Walmart might say, okay, maybe don't hire as many women this year, right? Because we already have too many pregnant women that we're gonna have to pay healthcare costs for. So it's important to think about the management practices that can stem from wellness programs and the ways that they can be used in a way that's discriminatory or also invent privacy invasions. So for example, when Castlight was tasked with figuring out which employees were either pregnant or bound to soon become pregnant, they were also tasked with nudging those employees. As in, if you're one of those employees, Castlight might find out that you are already pregnant based on the prescription drugs you're using, right? Because when you sign up for the wellness program, you also sign up for their app. And the app would collect information on what prescriptions you're using. So for example, if you suddenly stopped using prescriptions that pregnant women couldn't take, or you started taking pregnancy supplements and you entered that into the app, now Castlight knows that you're pregnant and sends you more information about pregnancy even before you might actually be ready to announce your pregnancy to anyone. So this, of course, can feel like a huge, huge privacy violation. Okay? So beyond the privacy violations, however, you might be asking, what are the other ways that wellness programs can actually be a backdoor to discrimination? Well, for one thing, the two main categories that wellness programs cover in terms of lifestyle factors that they address, obesity and smoking, these are not protected categories under federal anti-discrimination laws. So as an employee in America, you know that you can't be fired for being pregnant, ostensibly, right? You can't be fired for being of a certain race. You can't be fired for being of a certain religion. However, your employer generally can fire you for being too fat. And in 9 states, clearly, unequivocally, your employer can also fire you for being a smoker, for having the status of a smoker, right? And how would your employer know this? If you never smoked in the workplace, how would your employer actually know that you're a smoker when you sign up for their smoking cessation program, right? So it's important to keep in mind all the insidious ways that wellness programs can actually come back to hurt the employee, even while it's being presented as something that is benevolent for the employee. Okay, so what's the solution? Do employers have a cognizable interest in preventing obesity, in making sure that their employees are not smoking and therefore essentially jacking up insurance costs for everyone? Of course, right? But do employees also have a cognizable interest in keeping their private lives private, including their pregnancy status, their smoker status? And do employees also have a cognizable interest in not being discriminated against based on physical conditions that are not impacting their job? Of course. So the question is, if wellness programs are allowed to continue and they enjoy the support of the government, what regulations should be put in place to ensure that they actually could work for the employee rather than be a burden? Right? And then there's the question of informed consent. Do workers, when they sign up for wellness programs, actually know fully how the collected data will be used and where it will end up? Another news story found that a significant percentage of wellness program vendors do sell the data they collect, right? They had denied it, but this news story actually found that, yes, a significant percentage of them do sell the data they collect to third parties beyond what the employer could ever have imagined. Should there be regulations of this sort of data transfer? Should there be informed consent on the part of the employee that's giving up this health data? And finally, there's the use of wearables in wellness programs. A lot of wellness programs employ gadgets like Fitbits and all the types of wearables to sort of give the employee an assessment of their daily activities and et cetera. Should the employee also know about, first of all, issues associated with those sort of gadgets in terms of their accuracy and reliability, right? Should the employee also know about the terms of service of those types of gadgets? I recently took a look at a website that has actually accumulated all the terms of service of all the wearables, and almost all of them tell you explicitly that they do sell your data. How many people knew this? I would say very few people actually knew this because, as mentioned earlier, we don't read the terms of service, right? But if your employer is essentially inducing you to enter into a wellness program, right? They're enticing you with that premium reduction. Should they also be telling you about the risks associated, such as the fact that your private health data could end up with third parties beyond what you could have imagined, beyond what you could have expected, and could be used in ways that potentially put you at risk or that target you monetarily for ads? So I leave you with this thought. What does it say about us when the worker becomes a cost, right? What does it say about us as a society when the worker is viewed as something that must be addressed in terms of cost savings? What does it say about the personhood of the worker? And what does it say about the future of work? Thank you very much, and I look forward to your questions.
Before we stop, does anyone have any questions for Professor Ajunwa?
Go ahead.
Sure. Wait, please, yeah, if you don't mind using a microphone.
I don't think this thing works.
Well, you have to hit the button on the bottom and then, or something like
It's
that.
working.
Oh, is it?
Everyone's telling us to read the user contract. the user contract on a $50 Apple product is longer than King Lear.
Exactly.
It's not a joke. Reading the contract when the contract is intensively and intentionally unreadable is not very helpful.
That's a really good point, and it actually speaks to a revolution that's starting to happen in terms of contract law and also how people can be deemed to have given consent. Because a lot of these terms of service are unduly inscrutable, right? They're written in legalese, they're very difficult to understand, and the question is, why do we allow this, right? Why can't we enforce that companies write terms of service in a way that's accessible to the consumer, in a way that's easy to understand and digest?
Could you tell us what the website is that compiles all of these terms of service?
Oh, I don't have it with me, but I can send it to you. Yeah, just give me your card after and I'll send it to you. It's on my Twitter, by the way, if you're on Twitter. I'm at Ajunwa. That's me. At IAJUNWA. That's my
Her
Twitter.
name's in the book.
Yep.
Quickly.
But I posted
One
it.
of the things that bothers me a lot about, there's a lot that bothers me, and if anybody wants to see what one of these wellness questionnaires looks like, if you've never seen one, come see me afterwards, is that they talk about discrimination. The premium reductions and the changes that are considerable, like can be into the thousands of dollars
Exactly.
and tens of thousands if you've got a big enough policy in a family. And you basically means that if you don't want to give up your data, you better be rich, because you
Yeah.
can absolutely not afford to not agree to do these things otherwise.
That's an excellent point. So the government, under the ACA, it explicitly says that corporations can only give incentives and not penalties. But if you think about it, a 30% or 50% incentive is also a 30% or 50% penalty if you don't join, right? So it's just a matter of phrasing. It's a semantic, right?
So, is this on? Yeah, I think it is. Okay, I have a friend who's a VP for a company I will not name that does wellness programs, but it's a big national program. And we've had this discussion, and I'm a little confused. Okay, so you said that it doesn't have to comply with HIPAA under circumstances if it's not. I mean, if they've been hired as a company by an employer, what are the HIPAA expectations? And then, again, her thing was, oh, it doesn't matter, it's de-identified data. And
Right.
so no matter what, are there ways, whether it's regular commercial insurance companies or self-insured employers, that it can hurt people more too, in terms of the discrimination? Like, do self-insured companies have more capacity with these wellness programs too? So I'm really confused about this whole thing about what
Yeah.
they can do.
I'll answer sort of simplistically, but essentially, HIPAA only applies to entities that are healthcare providers, right? So an insurance company could be deemed to be a healthcare provider, but a lot of wellness program vendors are standalone, meaning they're not attached to an insurance company. They're just a standalone company. And in that case, they're really not a healthcare provider, at least not yet. So it's still, definitely up for debate, but not yet. Now, in terms of what HIPAA can actually protect, I think it's also important to understand that the P in HIPAA does not stand for privacy. I love to say that always, because there's this general impression that HIPAA is protective and it's protecting my privacy. Not really. The P in HIPAA stands for portability. And the idea is still that even with HIPAA, one provision of HIPAA is actually that the information can be shared for payment purposes. So if, for example, your employer is contesting a claim and wants to see exactly what they're paying for, well, that's allowed under HIPAA. They can share that for payment purposes, if that makes sense. So HIPAA has much more limited protections than you really imagine. Yeah.
This is not a question, it's just more of kind of maybe an answer to your statement about kind of the terms of service and making them more clear. I'm a sociologist, and I rely upon someone like Dorothy Smith, who was a institutional ethnographer who studied documents to study power of institutions. And basically, the terms of service are telling all of us who holds the power.
Exactly.
And they're not going to change them. They're not written to be read. They're written to tell us who has the power, and it's not
Essentially.
us.
Yep.
The implementation here is interesting. I just thought I'd comment on two things. I've been over in West Virginia for 3.5 years, and our state plan decided they would reverse the procedure and they would hit you with a penalty rather than a discount. And my understanding of the rule is that's illegal.
It is
But they
illegal.
instead increased the deductible, and they extorted that out of all of us and said, you've got to go through the screening. Even the basis on which this was done, cholesterol level, and of course, I'm in West Virginia where we have the highest obesity and some of the worst chronic disease. They picked 245 for the cholesterol level, which has never been in the literature as a cut point for anything.
Exactly.
But then in addition to that, I think the one thing you haven't indicated, which gets into another level of discrimination, is they're now going to tie these in escalating steps. I know we're doing it over in West Virginia, to achieving numbers.
Exactly.
So this was an argument I made. I know when we worked on the ACA, you're in a situation
Yeah.
where you're getting in genetic discrimination and other things. And I remember mentioning Senator Snow, we were working on this and arguing the point. Two people both take, I said, if it's, I wouldn't object so much if you were talking about asking two people to do the same thing. If you and I both take Lipitor and my number comes down and yours doesn't, you get a penalty. And that could be thousands of dollars, which completely undermines the whole idea of no pre-existing conditions.
Yeah, so the EEOC guidelines are saying that that's illegal. So the EEOC guidelines is saying that you can't actually tie the wellness program rewards to actual outcome. Like you can't tie it to actual outcome.
But
That doesn't mean that people
The
don't.
backdoor they do is they
Yeah.
say, we won't do it if you give us a letter from your physician, but how many individuals are going to produce that letter on time and go get it?
Yeah,
You know, so
exactly.
it's onerous. Thank
I think he was next. Thank you very much.
Great talk, Ifeoma, and
Thank you very
I like the paper as well.
Thank you.
But so I wonder whether you would agree with the following statement. That the solutions for the problems you identified, the problems are privacy problems, but the solutions don't necessarily lie in privacy law. Because the first seems to be a contract law problem, right? The idea is that in privacy contracts, but also in other kinds of consumer contracts, people aren't understanding what's happening. You have arbitration clauses that don't allow them to actually litigate the disputes. And so really, we need to, repeal the Federal Arbitration Act or rewrite it, at least. And we need to make sure that contracts in general are understood. The second is an anti-discrimination problem. Because what's happening here is that, in fact, so the issue may be, you may be very good about, you may understand the contract, you may say, I'm not going to do this. But the problem is that if you are a woman who wants to get pregnant, they've never got your data. They're using other people's data to build your profile, right? So it's not your privacy directly that's been infringed, but you are suffering the discrimination of the big data analytics that they are conducting. So you're suffering a discrimination in that context now.
Right,
And so that seems to be an anti-discrimination problem with the problem in anti-discrimination, with the solution in anti-discrimination law, right? So I'm wondering if that is a correct statement, that the solutions don't necessarily lie in privacy law as opposed to contract consumer protection law and anti-discrimination law.
Yeah, I frankly tend to agree with you. And I actually have a law review article I wrote about genetic discrimination that actually looks to contract and tort law as a way to sort of solve some of those issues. Because as you know, the Genetic Information Non-Discrimination Act, GINA, is actually quite limited in what sort of redress it offers to consumers. Especially for people who are doing direct-to-consumer genetic testing. So I actually tend to very much agree with you that this is an issue that very much implicates contract law, although not necessarily in the way that you're framing it. I think it very much implicates contract law more from the employer-employee standpoint in terms of when employees are signing up for these wellness programs, can they actually really be said to be willingly consenting, right? Because that's part of contract law, willingly and knowingly, right, sign the contract. But if you're saying, I'm holding hostage, right, a part of your premium unless you sign, which is like your health insurance, and which in some jurisdictions outside the US, health insurance is viewed as a universal human right, then is it actually a fair contract? Is this more of a contract of adhesion or an unconscionable contract? So that's probably more where I would focus in terms of the contract law issue. And the discrimination issue is definitely well put in that this is basically a way for companies to sort of discriminate against protected classes, because pregnancy is a protected class. But if they're saying, oh, we're de-identifying the information, then it becomes not about the individual, right? And you usually need an injured individual. Of course, the work of Latanya Sweeney makes de-identification a joke, right? As we see how very easy it is to just de-identify, to re-identify people based on just publicly available databases. But thank you very much for your question.
I had a question about employee assistance programs, whether the ACA altered the HIPAA guidelines for them, and if you could compare the privacy protections for employee assistance programs versus wellness programs.
That's an area that I just started looking into, and I'm not quite as versed in that area as I am with wellness programs. But from what I know, I don't think there's greater privacy protections for employee assistance programs than for wellness programs, no.
Well, I think we'll stop now. You can keep talking with her. She's going to be here this evening. And so let me tell you a couple of things. We have a really exciting gala this evening, and Senator Markey is going to come and present the Brandeis Award. He's a former awardee. And so that is going to start at, the gala is going to start at 6:30. And if you don't have a ticket, it's still possible to get one. So please come promptly at 6:30, because the senator is going to be very prompt and you won't want to miss anything. So, so thank you for coming today. Thank you for all of your great questions. And certainly we have to thank all of our amazing speakers and moderators for
Thank you, Deb.
everything that they've done.
Thank you.
And the great food for thought. And tomorrow, after the gala, we hope you'll come back tomorrow. We've got amazing panels then. And we're going to kick it off with a keynote by Adam Tanner called MedMen, The Secret Origins of the Medical Data Business. So kind of a mystery for us. You're going to unravel the mystery, right, Emmett? Okay. Well, thank you all, and we'll see you tonight and tomorrow. Thank you very much.